Good morning. This meeting will come to order. This is a public meeting of the Commodity Futures Trading Commission to consider an issuance of one interim final rule and two proposed rules. It's an interim final rule relating to the time frame for the reporting of pre-enactment unexpired swaps to a swap data repository or to the Commission itself. A proposed rule that would prescribe certain financial resource standards for derivative clearing organizations, including those clearing organizations that may in the future be designated systemically important by the Financial Stability Oversight Council under Title VIII of the Dodd-Frank Act. And as that council's first meeting is later today, of course, these designations are not yet made. And thirdly, a proposed rule specifying requirements for derivatives clearing organizations, designated contract markets, and swap execution facilities on their governance arrangements and ways to mitigate conflicts of interest. This is the first public meeting that we have had to consider rulemakings under Dodd-Frank, Wall Street Reform and Consumer Protection Act. The next meeting will be scheduled for October 19th. We anticipate putting out the Federal Register notice for that. We also anticipate continuing to have meetings through the fall approximately once a week. We're still working on our collective schedules, but we will notice each of them and the specific topics to be discussed on those meetings through the Federal Register as we go along. We will hear from the staff today, and I'd like to thank my fellow commissioners for all their hard work on the passage of Dodd-Frank Act. That was a team effort, but now we have these existing authorities. I certainly particularly want to thank their input into these three proposals, but the many that we have coming in front of us. We have a challenging agenda, but I know that the staff is up to it. I know for sure the commissioners are up to it as well. I'd also like to welcome members of the public. Two members of the public that are particularly special that I want to welcome is John and Bev O'Malia. Commissioner O'Malia's parents are here, and I don't know if they were going to have particular comments on these rules, but we look forward to all of the public's
I'm going to have them edit my statements next time.
Yeah. Having met them, they might have different views, though. I don't know. But all market participants, members of the media, today's meeting, as well as welcoming those listening to the meeting on phone or watching live on webcast. I'd like to thank the staff for all their hard work. This was passed July 21st, and they had their first initial thoughts and memos into the chair within days sometimes weeks, but to the full commission within 4 or 5 weeks, and term sheets and the debates and dialogues with the SEC and the Federal Reserve and the other prudential regulators. It's just been an enormous accomplishment. I'm so proud of what you all have done. And you've been able to incorporate as best you can all the thoughtful recommendations from fellow regulators, certainly the many thoughtful comments from our commissioners here, and considering international regulators as well. This is the first step in the long path. 2 of the rules are proposals, and we look forward to receiving public comment. And that public comment is critical. The final rules often are similar to the proposals, but they naturally change as we get the full input from the public. And certainly I know for me, that's going to be very important as we move forward. With regard to the interim final rule on swap data repositories, staff will come back later in the fall with specific proposals at the appropriate time on those swap data repositories itself. This is just about a specific feature of Dodd-Frank about pre-enactment swaps. We've organized ourselves around 30 rulemaking teams, and they're all actively at work. So we'll be reviewing additional recommendations from these teams as well as other teams in similar format going forward. Before I turn to the staff, I'd like to turn to my fellow commissioners. Commissioner Dunn.
Thank you, Mr. Chairman. And I appreciate the hard work of the staff. As I look out there, I see you've twisted Susan's arm just a little too far to get her to give you everything we need. But we began the first steps in implementing Dodd-Frank Act. This is this country's most significant financial reform bill during my entire government service. While Congress worked for nearly 2 years crafting the legislation, they have charged us with implementing it in 360 days. For an agency the size of the CFTC, with a very limited fiscal and human resources at its disposal, this will be a Herculean task. Under the leadership of Chairman Gensler, almost a third of the CFTC staff has been working in 30 areas to develop the rules necessary to implement this legislation. We will be holding a series of public meetings this fall to consider rules in an effort to meet the timelines mandated by Congress. Congress has worked hard. Our staff is working hard. And now it is time for the public to go to work. In most cases, we will be adopting proposed regulations. There will be a period of time for the public to comment on those proposals, and then we will adopt final regulations taking the public's comments into account. If we are to get it right, it is imperative that we have a firm understanding of how the regulations created will impact the markets we regulate and those who use them. It is the role of the public to help us understand that impact. Your input begins now. Please take the time to review and comment on these proposed regs to ensure we succeed together. Due to the congressionally mandated deadlines, comment periods may be much shorter than we might desire, and extensions of comment periods may not be feasible. It is therefore crucial that those desiring to have input in this process do so as soon as possible. Your comments are important in shaping the final outcome of the regulations. As a commissioner, I intend to be liberal in letting proposed regulations be published. This includes proposals that I may not entirely agree with. I intend to keep an open mind and take into consideration the public's comments when making a decision on a final rule. As staff works to prepare these proposed rules, I would ask them to keep two concepts in mind. First, I believe that the principle-based regulatory regime that the Commission currently adheres to works well. It is no coincidence that with the advent of principle-based regulations, the markets we oversee experienced a new wave of innovation and explosive growth due in no small part to the nimbleness of the CFTC. To the extent possible, I will ask that staff continue to follow our principle-based regime and forego prescriptive rules that mandate one-size-fits-all approach. Second, I also believe that there are several approaches this agency can take to implement Dodd-Frank and still follow the intentions of the drafters. I would ask the staff to present alternatives and proposed regulations that would allow the public to comment on more than just one solution and allow the commissioners to have choices in final rules adequately considered by the public. I would be remiss if I did not mention one other externality that will have a major impact on rulemaking process. Adequate funding of the CFTC is essential to fulfill the mandates of Congress. During the debate over this legislation, the CFTC was asked to provide an estimate of the cost of implementing various provisions of the bill. This estimate was based upon being funded at current request levels for FY 2011, with additional resources to reflect the burdens imposed by the new law. Without full funding, it will be impossible to meet all of the law's mandates and continue to fulfill our duties under the current law. This puts the Commission in a position of choosing what parts of Dodd-Frank we actually have the resources to implement and whether we can do so while continuing to fulfill the core mission of the agency. I would ask the staff provide an estimate of the cost of each proposed regulation and an analysis detailing whether the CFTC can delegate duties to SROs to fulfill the mandates of Congress. Further, I would ask the staff, working in concert with the chairman, to provide the commissioners with a list of prioritizing regulations based upon available funding. It is also important that the implementation of Dodd-Frank means that certain services the CFTC provides will no longer be provided. Those services must be made public. Finally, I would ask the staff begin to determine what rules and regulations the CFTC can rescind as a result of the adoption of new rules, and I would encourage CFTC commissioners in the future to review the Dodd-Frank rules within 3 years of enactment to determine if they are actually doing what they were designed to do. I want to thank you, Mr. Chairman, for your leadership and the hard work of the dedicated employees of the CFTC in preparing these and future proposals.
Thank you, Commissioner Dunn. Commissioner Summers.
Thank you, Mr. Chairman. Good morning. Now that Congress has done its part over the last year and given us Dodd-Frank, regulators are tasked with putting meat on the bones by crafting the many regulations required to give effect to the statute. Generally, the headline from Dodd-Frank is that the OTC swaps market will now be subject to stringent regulatory oversight. To implement this regulatory oversight, we've set up 30 rule-writing teams that are drafting dozens of regulations that we expect to formally propose before the end of this year. This is a very ambitious agenda, but Congress has given us little choice with the statutory deadlines imposed. While the rule-writing teams are composed of very capable and hard-working staff and have already been working for months, they still have a daunting amount of work ahead of them. The Commission began the process of publishing rules last month. So far, we've published final rules relating to the retail Forex trading, a project that dates back to the passage of the 2008 Farm Bill and was also included in Dodd-Frank, a petition process for grandfathering exempt commercial markets, and an advance notice of proposed rulemakings for agricultural swaps. Going forward, the process of proposing new rules will begin rather quickly. Today, we hold a meeting to vote on 3 agenda items from Dodd-Frank. I fully expect there to be many more such meetings, as the Chairman just discussed, where the Commission will publicly deliberate and vote on these proposed rules. I want to continue to urge all interested parties to engage in this transparent process. Commenting before a regulation is proposed can be very helpful, as well as commenting after a proposal has been published. It's imperative for us to have this input from the stakeholders, and I agree with Commissioner Dunn about encouraging you to do it as soon as a rule is proposed. Some of the issues we are discussing today are much more complex than they first appear. Adding to the complexity, many of the provisions require multi-agency coordination. I know the Chairman and the rulemaking teams have been very mindful of the importance of successful cooperation among regulatory agencies that are tasked with enforcing this new statute. Without continued progress in this area and consistent rule proposals, the agencies risk injecting additional uncertainty into the already complex process by which the OTC markets and participants will come under the regulatory regimes of one or more agencies. In my view, additional uncertainty could be devastating, and I will do all I can to ensure that we do not have such an outcome. It goes without saying that market regulators have their hands full. Achieving these reforms will take time, and comprehensively changing the regulatory landscape in such a short period will not be easy. I recognize that it is imperative that we get it right, and that our goal as regulators is smart regulation. We can do damage to these vital markets without that goal. I fully intend to do all I can to make sure we don't get it wrong and that our markets continue to thrive. I want to thank the staffs of these 3 rule-writing teams for all of the work that they have done to get these proposals ready in such a short amount of time. I know you've spent a lot of long hours and want to let you know how much we all appreciate that. Thank you.
Thank you, Commissioner Summers. Commissioner Chilton.
Thanks, Mr. Chairman. I was thinking about this last night, and I was thinking about that old Chicago song. I don't know if people remember it, but I'm going to put it in your head for the day if you do. Only the beginning. Remember, it's only beginning. It's only just the start. And so this is the first public meeting that's just the beginning and just the start. and it's important, and I thank all the staff who've been working double time on this. There's been a lot of talk and a lot of news articles lately about the flash crash, and there'll be more on that in the next little bit. But here's what's clear, that these markets are all interrelated. The securities markets, the futures markets, even the global markets. And to the extent that we can harmonize in the U.S. and globally, as the chairman's been talking about earlier this week in Brussels, it's really critical. And so some of the things that we're doing in the markets with our brethren regulators, particularly the SEC, but with our other regulators, sister regulators around in the U.S. government, they're Band-Aids. They are important. They're significant. Like Commissioner Summers said, I think these are imperative changes that we're doing. But the work that we're doing today, that we're starting today, are the real structural changes. This is the Dodd-Frank stuff is the long-term stuff. And I share Commissioner Dunn's concerns about the funding. We can deal with some of these issues with a flash crash, but these longer-term things, if we don't have the money, I think it'll be really tough for us to aggregate position limits, much less enforce them. I think doing the clearing that's required, particularly with regard to what's currently dark markets, the OTC trades, that'll really just be, I think, almost an insurmountable task for us. Likewise, the new authority we've been given, enforcement, disruptive trading practices, going out and investigating these things, that's another thing, whereas the Commissioner Dunn said we're going to have to make some tough choices if we don't have the money. And finally, dealing with things like the advent of high-frequency trading. Not saying it's a good or a bad thing, but it's certainly something we need to get our arms around. So I hope that we get the funding we need. We can make it for a few months. We can put the rules in place, but we can't actually monitor them and oversee them like Congress intends. So this is just the beginning and just the start, and I look forward to doing the work we have to do with all of you. Thanks.
Thank you, Commissioner Chilton. Commissioner O'Malley, did you want your folks to do the statement?
No, no thanks. I do appreciate having them here. While I am under no illusion that grandchildren might have been a stronger draw than a commission meeting, it is good to have them in my corner. I would also like to echo my fellow commissioners in thanking the staff for the very hard work that has gone into these rulemaking long hours has resulted, and this is the culmination of that, and we're going to put these rules out. I'd also like to compliment the other 27 teams for their work in identifying issues and preparing the proposed rules. I can say from firsthand experience that the amount of paper and the number of meetings that I've endured is overwhelming. It's a massive amount of work. The staff is under great pressure and to come up with options and ideas, and we appreciate all the work that they do to give us those options so we can make informed decisions and then obviously put them out for public comment, which is essential, and I strongly urge the public to comment. It will be under tight time frames, but their input is essential. With regard to the rulemakings today, I intend to support all three. However, I have a number of concerns associated with the prescriptiveness of the proposed conflict of interest rules. I believe that we have other remedies within Dodd-Frank that could be more effective in achieving the goal of expanding access to clearing. With regard to the conflict of interest, I'm mindful that the main goal of this act is to reduce systemic risk. And by imposing mandatory clearing, that's the way the Congress has chose to achieve that. The business of clearing is serious and a financially complex matter, and it should be treated as such. I am concerned that the proposed rules seek to impose limited and inflexible ownership caps and not afford the Commission the flexibility to consider all statutory objectives, including promotion of competition and reducing systemic risk. In addition, I'm quite confident that the open access and participant and production eligibility provisions in Section 2H and 5B under the Act will be more effective in guaranteeing access to clearing than the ownership rules, which I believe to be an imprecise and ineffective tool to enhance competition, mitigate systemic risk, and resolve conflicts of interest, all specified in the statute. With that said, I do appreciate the inclusion of the waiver provisions, working with the Chairman's staff, that will provide the Commission with a greater flexibility. And considering the Commission is yet to receive a single DCO application, I believe this flexibility is warranted. With regard to the financial resources core principles B, this rulemaking is the first among many designed to mitigate systemic risk through clearing in the swaps market. However, as the Commission proposes rules to implement the Act, DCOs will be required to meet more stringent capital requirements, which will be passed on to their customers. Market participants should have no illusion that the cost of clearing will increase. At the end of the day, it remains to be seen whether lower returns on capital and higher transaction costs will have its own unintended negative impact on liquidity, competition, and innovation in the markets. The interim final rule on margin and pre-enactment swaps. I agree with the Commission's decision reporting swaps entered into for the enactment, and I know many commercial entities are interested to know whether or not the Commission will impose margin on these pre-enactment swaps. I understand this is an issue that will be addressed in a future rulemaking, but I would like to take the opportunity to make it crystal clear that I oppose interfering with privately negotiated contracts entered into prior to the Act, and I believe that any rule or regulation designed to do so would be of questionable legality and an extraordinarily unwise policy decision. Mr. Chairman, I'm pleased that we're going to have this first rulemaking. I look forward to the many rulemaking meetings to come and have our say in these things. With that, let's move on.
Thank you, Commissioner May. I find I want to associate myself with so many of the remarks of my fellow commissioners in the opening, but particularly that we really do look forward and need the public's comments. I'm going to, as you'll see, support all three of these rules. But I suspect 6 months from now, or in the case of the governance, just 3 months from now when we try to finish it up, that I will have changed my mind on all of these because the public's views are really important. And so I think we've all stressed that, and that's what's so important. These are just proposals. These are to get the public dialogue really moving to the next stage. And I don't think they should be confused with where we'll end up as a final rule. We have 288 days to go until we finalize all this. We've had 170-plus meetings with public participants that we list on our website. We counted it up. We've had 145 meetings, at least with fellow regulators. 100 of those are with the SEC. We didn't count up the international regulators, but there's probably a dozen to 15 more. But with that, I'm going to the first proposed rule we're considering today is an interim final rule relating to the time frame for reporting pre-enactment swaps. These transactions existed before the President signed the bill, and so what Congress asked is that those pre-enactment swaps that are still in existence be reported to a swap data repository, and that's why it comes to this. Susan Nathan from the CFTC's Division of Market Oversight will be presenting an overview of the proposed interim final rule. Rick Schiltz, who's the head of the Division of Market Oversight, will be, I guess, supporting Susan and giving guidance to Susan as her boss, but Susan and Rick will be presenting. The second set of proposed rules, I'm just going to introduce the whole panel and then we'll hand it off. The second set of proposed rules being considered today prescribes certain financial resource standards for derivatives clearing organizations. These are the organizations that have existed actually from the 1890s that help lower risk to the American public, that stand between parties in these complex transactions. Phyllis Dietz and John Lawton from the CFTC's Division of Clearing and Intermediate Oversight will be presenting here today. Ananda Radhakrishnan, who is their boss and the head of the Division of Clearing Oversight, I guess will support Phyllis and John and give them direction. Finally, the third set of proposed rules being considered today specifically require derivative clearing organizations and various exchange platforms, what we call designated contract markets and swap execution facilities, to have certain governance arrangements and mitigate their conflicts of interest. And I think this is the one that's had the most debate, not only here amongst the five of us in private 101 sessions, never on the wrong side of the Sunshine Act, but also public debate. This was a very healthy debate in Congress as well, so I do look forward to a lot of comments there. But Nancy Schnabel from the Division of Clearing and Intermediate Oversight, with Ananda's support and guidance as well, will be presenting that. So the procedure will be, we'll go down, you'll present, Susan and Rick will do this first one, and after your presentation, I'll entertain a motion, and then we'll have questions and debate and a vote, and then we'll move to the second and third. But with that, Susan and Rick.
Thank you, Mr. Chairman, Commissioners. I'm pleased to provide a brief summary of this interim final rule. Essentially, this rule imposes a present obligation on counterparties to preserve transaction data associated with swaps executed prior to the enactment of the Dodd-Frank Act, and a future obligation to report that data to an appropriate registered swap data repository, or SDR. Before discussing the substance of the rule, I'd like to remind the Commission that this rule is styled as an interim final rule. Interim final rulemakings are designed to permit a federal agency to adopt as final, for good cause shown, a rule that hasn't been noticed for comment in the Federal Register in the traditional way. Instead, the agency may publish the rule as final while concurrently soliciting public comment. Frequently, public comment received in connection with an interim final rule will be responded to if and when a permanent rule is subsequently proposed by the agency. Here, good cause is demonstrated first by the explicit direction in Section 729 of Dodd-Frank, which requires the Commission to adopt such a rule. In addition, staff believes that an interim final rule is warranted in these circumstances by the necessity to promptly provide notice to swap dealers, major swap participants, and other counterparties that they may become subject to reporting requirements which necessitate that they preserve data relevant to those transactions. Among other things, Title VII of the Dodd-Frank Act amended the CEA to require that swaps be reported to a registered SDR or to the Commission if there is no registered SDR that would accept the swap. Practically, this might occur where no SDR has yet been registered by the Commission or where no SDR has been approved for a particular asset class. Section 723 of Dodd-Frank adds Section 2H5 to the CEA to require that swaps executed prior to enactment must be reported to a registered SDR or to the Commission no later than 180 days from the effective date of that subsection. So that would be approximately 540 days from enactment. The statutory provision that is directly relevant here, which is 729, establishes in new Section 4R of the CEA reporting requirements in connection with pre-enactment unexpired swaps, those entered into before July 21st, 2010, and unexpired as of that date. And that rule will remain in effect until the effective date of the permanent reporting rules to be adopted pursuant to 2H5. Specifically, Section 4R provides that within the time period prescribed by the Commission, each swap must be reported to a registered SDR or where there is no SDR that would accept the data to the Commission. This section further specifies that each pre-enactment unexpired swap must be reported to a registered SDR or the Commission and directs the Commission to promulgate within 90 days of enactment of Dodd-Frank an interim final rule governing the reporting of such swaps. It's anticipated that the provisions of this rule will be supplanted by the permanent reporting rules to be enacted pursuant to new CEA Section 2H5. But in the meantime, these will govern how these swaps are to be treated. Consistent with the mandate of Section 729, new Part 44 of the Commission's regulations will first establish a reporting time frame for pre-enactment unexpired swaps that is no later from 60 days from the date the appropriate SDR is registered with the Commission or by the compliance date that will be established in the swap reporting rules required by new Section 2H5 of the CEA, whichever comes first. And two, will require that swap reporting parties specified in Section 4RA3 of the CEA, and those are swap dealers, major swap participants, and other counterparties, report information concerning such swaps to the Commission on request during this interim period. The Part 44 rules will specify the information to be reported under the interim final rule, including a copy of the transaction confirmation in electronic form where available, and two, if available, the time the transaction was executed. The rules additionally provide that the Commission may request from reporting parties any information related to a swap transaction. Part 44 also includes an interpretive note explaining the Commission's view that in order to comply with the reporting requirements of Part 44, each counterparty to a pre-enactment unexpired swap transaction that may be required to report that transaction must retain in its existing format all information and documents related to the terms of the swap transaction. The requirement takes the form of an interpretive note because a retention requirement is not explicit in Section 4R. The requirement to retain information is nevertheless, in staff's view, implicit in a future reporting requirement. Thank you, and I'll be happy to entertain any questions.
Thank you very much, Susan. I think the chair will now entertain a motion to accept the staff recommendation to issue the proposed interim final rule relating to reporting of pre-enactment swap transactions to data repositories or to the CFTC.
So moved.
Second. All in favor?
Aye.
Oh, no, that we shouldn't. There's questions. I'm supposed to let questions happen. So we were all. I know where we are, but are there questions for Susan or debate? Commissioner Chilton.
Susan, thank you, and thanks for all your work on this. I know you've spent a lot of time on it. I was looking through the comments online, and for those of you who don't know, we're taking them even before we have these proposed rules. They've set it up on our website, and there's a lot of them up there already. On this one, the Electric Power Supply Association sent us a comment and talking about the transition rule, but they're concerned that, since we don't have the definitions done yet for major swap participants or for SDs, they wonder whether or not institutions with should be responsible for. They think they're going to have a reporting problem, and that there's perhaps let me just get it right. What they said. I'm looking for specifically what they said. A particular point of view, recommending that financial institutions with prudential regulators be responsible for reporting, or if there is, perhaps it should be the seller. What's your view on that?
I'm not sure I entirely understand the comment. If their concern is that they may be subject to a reporting requirement before it's been determined that they should be subject to a reporting requirement, I think the best advice is that if they preserve the data until such time as these definitions are in place, it will become clear to potential reporting parties before there is any present obligation to report whether or not they are affected by these rules.
And I think, because we're allowed to deliberate, I think the question that's come up by many market participants is, might I be a major swap participant? And at least how I was asked this question in a congressional hearing yesterday, and I can't say where you all are, but I think Congress has really laid out 3 criteria in that circumstance where this should be a very narrow set of companies. There are people that are not otherwise swap dealers, and yet under each of these 3 prongs have some systemic relevance. Their positions in the swaps market are such that it's, that Congress would deem, and through us, the rulemakers deem that they should have a full regulatory regime. So I'm hopeful when the SEC and we finish up the rulemaking that it will be quite clear this is a pretty small set of parties.
I had one more, if it was okay. We've heard a lot about the practical problems with real-time swaps reporting for non-financial organizations that are designed to capture trades as they occur, both in the grandfathering phase and in going forward. And that this would be a compliance burden for them and perhaps even an enforcement problem, front-running, for example. How does this address that? How does this proposal address it?
If I'm understanding your question, I'm not sure that this proposal does address that.
Okay. Well, like we said, we look forward to getting comments.
Commissioner Dunn.
Thank you, Mr. Chairman. Susan, I'm just kind of get it straight in my mind and the public's that this is an interim final rule under the Administrative Procedure Act. It goes into effect immediately. But there is a comment period, and we have, 30 days on this one for people to look at it and comment on? And so, under the Administrative Procedure Act, we can take those comments and we can change this interim final rule. What we're really waiting for is the permanent rule on reporting.
That's correct.
So, again, it's incumbent upon the public to take a look at this. If they think we've missed something or we should have included something, they can comment within 30 days. But after that period, this is what will be in effect until the permanent rule
Until the
is.
permanent rules are in effect.
Yeah.
Commissioner Summers?
I'm going to follow up on Bart's line of questioning and maybe ask if you could clarify, because I think maybe where the questions are surrounding these issues is not whether you are considered a swap dealer or a major swap participant, but the questions are surrounding what is a swap. So all of these people who have entered into transactions pre-Dodd-Frank and are not positive that these transactions are going to be defined as swaps have concerns about what information that they should or should not retain. So if you could maybe clarify your advice to people who are not sure about the transactions that they have entered into and whether or not they should retain that information.
My advice is that they should retain information necessary. I can give you a short laundry list with the caveat that you're absolutely right. We have no way of knowing now precisely who will be affected by the reporting rules. So the best advice would be for anyone who thinks there is the potential for reporting to maintain basic advice. Any information necessary to identify and value the transaction, the date and time of execution, information relevant to the price of the transaction, if the transaction was accepted for clearing, the identity of the clearing organization, any modification to the terms of the contract, and the final confirmation. That would be a kind of a small data set.
Thank you. I also have one other question in relation to the statutory language that requires pre-enactment unexpired swaps to be reported, and wondering if you have given any thought to considering exempting swaps from reporting requirements if they were unexpired before the date of Dodd-Frank but expire in the interim. And if it is useful for us to actually get reported, have swaps reported to us that have expired in the interim.
The statutory language, I take your point. The statutory language, though, is fairly clear that they want unexpired swaps, even if they were unexpired on the date of the legislation, then they count. And without any clear legislative guidance on that, I am assuming, and my counterparts at the SEC likewise believe, that Congress may have intended that this would give a good snapshot of what the status of the swaps markets were at that point.
Thank you.
To give a little bit more context to this question of definitions, which I think is an excellent question that Commissioner Summers raises, the SEC and the CFTC under the Act, as I understand it, have to do joint rulemaking on two sets of definitions broadly. Entity definitions. The swap dealer is pretty well defined in statute. Major swap participant defined in statute, but entity definitions will give more clarity to that. And then product definitions. Again, swap is defined in statute and it has a list of 15 or 20 things right there in statute, and it excludes forwards, for instance. But the SEC and CFTC will work together. Our current working goal is to get a proposal out in this fall I think that, in fact, we may have even ambitiously tried to schedule that for a November hearing, both at the SEC and at the CFTC. I say ambitious because these are really 10 commissioners ultimately will be involved, not just 5, and so there's just more moving part. But I think that will hopefully give some, it will only be a proposal at that time, but it will give some foreshadowing of a final rule that both commissions are trying to do definitions if we're successful before Thanksgiving. If we're not, hopefully, shortly after Thanksgiving.
Gee, Mr. Chairman, you make it sound like working with 5's tough.
No, I think that it's terrific, but it's 5 here, 5 there, the Federal Reserve, the international regulators, the FSOC, and taking all of the public's interest and the congressional intent.
For the interim, then, we're really allowing people to look at the Act, read the definitions that are in the Act, and then they have to make some assumptions on their own. Is that correct?
Yes, that's correct.
But before I call the vote, I just was going to make a couple of things. One, I wanted to clarify the comment period on this interim final rule is 30 days, just to make sure the public knows that. Again, as Commissioner Dunn, I think, helpfully pointed out. I am going to vote for this. I support the interim final rule. I think it fulfills the Dodd-Frank requirement that those swaps executed before the bill's enactment, but still in force at that point, be reported to a swap data repository or the Commission if no swap data repository in the future takes those. I'm hopeful that a swap data repository does, for all the resource reasons that several commissioners said. Under the interim final rule, swap participants would preserve pre-enactment swap transactions and report the data to a registered swap data repository once it's established. And since swap data repositories have not yet been established, I think it is an appropriate thing to give people time and to, in a sense, give them notice. The Dodd-Frank Act actually said we had to do this within 90 days. But so since swap data repositories are not registered yet, don't exist in that way, I think it is appropriate that we, in essence, to fulfill this requirement, are giving a delay to this and just asking people to maintain the I don't know if any of my fellow commissioners wanted to say anything more, or so then I would just...
Just one more on clarification, then. If folks do have doubts of where they stand, then they can contact the staff.
Do you have a...
Sure, they can contact someone here, and we'll try to provide guidance to the extent we can.
There's a motion on the floor. All those in favor?
Aye.
Aye. Any opposed? The vote being unanimous, the interim final rule should be sent to the Federal Register. I think now turn to Phyllis Dietz and John Lawton, and are you part of it? All right, great. We'll present the staff report on the proposed rule considering clearing houses, core principles, and systemically important clearing houses. Phyllis and John? And Ananda?
Thank you, Mr. Chairman. Good morning, members of the Commission. Today we're going to recommend to the Commission that it approve 3 rulemakings on the Dodd-Frank Act. The first one relates to proposed rules to give effect to DCO Core Principle B, which is in the statute, as augmented by Dodd-Frank, with respect to the prescription of financial resource requirements for derivatives clearing organizations, including DCOs that would be designated as systemically important by the Financial Stability Oversight Council pursuant to Title 8 of Dodd-Frank Act. The team leader for the first rulemaking is Phyllis Dietz of DCIO. The team leader for the systemically important DCO rulemaking is John Lawton, also of DCIO. Then the second set of rulemakings applies to potential conflicts of interest in connection with the interaction between swap dealers and major swap participants, and certain DCOs, designated contract markets, and swap execution facilities, and proposed rules to adopt numerical limits on control or voting rights that enumerated entities may hold in certain DCOs, DCMs, and CEFs, and also proposed rules specifying requirements for these entities on governance arrangements and mitigations of conflicts of interest. Team leader for that particular set of rulemakings is Nancy Schnabel of DCIO. Before I pass it on to my colleagues, I would like to thank the other team members of each of these teams. There was a lot of effort that went cross-divisionally. I'd also like to thank the Commission for their feedback on these proposed rules and the staffs of the relevant commissioners for their helpful comments. And with that, I will turn over to Phyllis Dietz. Thank you.
Good morning, Chairman Gensler and Commissioners. I am pleased to recommend that the Commission approve for publication the proposed rulemaking for Derivatives Clearing Organization Financial Resources. Prior to enactment of the Dodd-Frank Act, the Commodity Exchange Act set forth 14 core principles with which a derivatives clearing organization must comply in order to be registered as a DCO and to maintain its registration. Dodd-Frank revised several of the core principles, and it added 4 new core principles, bringing the total to 18. One of the core principles that was revised is Core Principle B, concerning financial resources. It was amended by the Dodd-Frank Act to require more specifically that a DCO possess financial resources that at a minimum satisfy 2 requirements. First, the financial resources must exceed the total amount that would enable the DCO to meet its financial obligations to its clearing members, notwithstanding a default by the clearing member creating the largest financial exposure for the DCO in extreme but plausible market conditions. This is what we refer to as the default resources. Second, it required that the DCO have sufficient financial resources to enable it to cover its operating costs for a period of 1 year, calculated on a rolling basis. These we sometimes refer to as the operating resources. The proposed rule before you today would codify the standards set forth in Core Principle B with additional specificity concerning 5 areas: the types of financial resources that can be used to meet these requirements, computation of required resources, valuation, liquidity, and reporting requirements regarding the DCO's financial resources. I would add to the earlier discussion about comment periods that there will be a 60-day public comment period for this proposal. Going back to each of these 5 areas very briefly, an overview. The types of financial resources that we are stating may be used to fulfill the requirements for default resources. That would include margin of the defaulting member, DCO's capital, guarantee fund, default insurance, if any, assessments of non-defaulting clearing members with certain requirements, and any other resource that might be acceptable to the Commission. The purpose of this catch-all provision is to provide some flexibility for both the Commission and the DCO in meeting financial resource requirements. With respect to operating resources, permitted would be DCO capital, and again, a catch-all for other acceptable resources acceptable to the Commission. Second, computation of required resources. This would require that a DCO conduct monthly stress testing to determine the financial resources needed to withstand a default of the clearing member with the largest exposure, and a monthly calculation of the financial resources needed to cover 1 year of operating costs. The DCO would be permitted to use its discretion in determining the stress testing methodology, but it would be required to take into account historical data and hypothetical scenarios. In valuing resources, the regulation would require at least monthly that the DCO compute the current market value of each financial resource. It would have discretion regarding haircuts to be applied, except in one instance. That would be with respect to assessments of non-defaulting clearing members. Assessments would be subject to a 30% haircut, and a DCO would only be permitted to count the value of assessments after the haircut to meet up to 20% of the financial resources requirement to cover a clearing member default. Fourth, the liquidity of resources. Financial resources would be required to be sufficiently liquid to enable a DCO to fulfill its obligations during a one-day settlement cycle, and sufficient capital in the form of cash to meet the average daily settlement variation pay per clearing member over the last fiscal quarter. In addition, the DCO would be required to have unencumbered liquid financial assets equal to at least 6 months' operating costs. There would also be requirements for a DCO's guarantee fund, which include prohibiting the use of letters of credit as a permissible asset. And finally, there is a proposed reporting requirement. The DCOs would be required to file quarterly reports with the Commission that, among other things, would describe the financial resources that they believe are required, provide the value of financial resources that are currently available, explain how the DCO meets liquidity requirements, and discuss the methodology used in calculating the financial resources requirements. Thank you.
Is it John?
Yeah, I was wondering whether John, it makes sense with John too.
Yeah, no, I think absolutely if we do the whole clearing piece and then Nancy gets to wait her turn.
Okay. Good morning. The rules that Phyllis just described are being proposed pursuant to Title VII of Dodd-Frank. The rules I'm about to describe are being proposed pursuant to Title VIII of the Dodd-Frank Act. Title VIII allows the Financial Stability Oversight Council to designate certain entities as systemically important. This includes DCOs as well as some other types of entities subject to jurisdiction of the SEC and the Fed and other entities. Basically, the staffs of the various members of the FSOC have begun consulting with regard to the designation process, but clearly the FSOC has not met yet, and no entity has been designated as yet. Pursuant to Title VIII, the Commission is allowed to prescribe enhanced risk management standards for certain DCOs that the Council has designated as systemically important. We have been calling them SIDCOs for shorthand. Basically, any DCO that was designated by the FSOC would be subject to all the standards that Phyllis has just described. In addition, there would be certain areas where they might be subject to enhanced standards. In the financial resource area, there are two modifications to the rules that Phyllis has described that we would propose with regard to SIDCOs. The first would go to the amount of financial resources that the DCO was required to have. The second would go to the valuation of those financial resources. As Phyllis described, the DCO rules in Core Principle B currently requires that a DCO have sufficient resources to cover its largest single exposure. For SIDCOs, we're proposing that they have sufficient resources to be able to cover their two largest exposures. So the effect of that would be that a DCO which was designated as systemically important would be subject to a higher financial resource requirement. The second aspect that we are proposing is that with regard to the valuation of the components of their resource package, as Phyllis described, there are certain haircuts that are being applied to any assessment power that a DCO would have if it had the power to assess non-defaulting clearing members in the event of a default. What we are proposing for SIDCOs is that any assessment power be haircut 100% with regard to the calculation for the first DCO with with regard, I'm sorry, to the calculation of the single largest default. With regard to the second largest default, it would be the same rule that Phyllis described. So effectively, again, the result of this proposal would be they would have to have more, a SIDCO would have to have more financial resources on hand than another DCO, because assessment powers are resources that are not in hand. They're something that you go to a non-defaulting clearing member if you need to. The other resources, such as margin and guarantee funds, are assets on hand. So basically, we have those two distinctions that we are proposing in the area of financial resources for systemically important DCOs. And we'll be happy to take any questions.
I think before the questions, the Chair will entertain a motion to accept the staff recommendations on the proposals concerning clearinghouses and the systemically important clearinghouses and how they comply with core principles.
So moved.
And this time I won't call now. All right, so now for questions, I might actually start, if I might. So one of the things from my trip to Europe this earlier week is that the Europeans have proposed to their parliament, and they're at least probably 9 months away from getting parliamentary action and finalizing it, that they have very prescriptive rules on clearinghouses, and that they would recognize U.S. registered clearinghouses, but only if they meet sort of an equivalence to European standards and international standards as put forward by this organization who's called CPSS IOSCO. I guess that's two organizations maybe. So in that context, I'm certainly, and I'm going to bring this perspective to each of our clearinghouse rules, want to know whether the staff's views and what you're recommending will the clearinghouses that are registered with us, if these would be the final rule, would they meet either the European test as we think it will come out on equivalence, or these CPSS IOSCO standards? John and Phyllis?
The proposal that under Title VII, the current CPSS IOSCO standard, for example, is that you must be able to meet the default of your single largest clearing members. So the proposal does meet that.
I'm sorry, you mentioned the current, I'm sorry to interrupt, you said the current IOSCO standards, but there's a draft as well. So
right, and the draft, again, it's still open. They're still discussing exactly what the final standard will be. It could be 1, it could be 2, or it could be 1 plus some other number that is not necessarily the largest. So that's still under discussion.
So if you look at the whole rule, those 5 areas that Phyllis went through, will it meet for the DCOs or international standards, or will it only meet international standards for the, so to speak, systemically important ones?
It will be consistent with and meet the standards, the international standards. In some cases, there may be even more detailed or higher standards, for example, in our reporting requirements. Based on the current CPSS IOSCO standards and what I have seen as, again, a draft, I think that our standards are a little more specific when it comes to reporting, and there may be other areas where it's a little higher, but certainly it meets the standards.
And then my second question is how does this compare to what I might call industry best practice and the guidance and rules that we've have in place? We currently regulate 14 clearinghouses, some small, some very large, but
I think it's generally consistent with best practice. Again, going back to that standard of meeting the default of your single largest clearing member. In doing DCO reviews in the last few years, we have in fact used that standard. We've been able to do stress tests which indicated that the DCOs were in compliance with that standard. Again, it moves because it's based on a stress test, so it's based on open interest, current positions. It's based on the inputs to the stress test, but basically we have done reviews in the past, and the DCOs are currently in compliance.
Okay, I'm going to turn it over to Commissioner Dunn, but I mean, again, the prism that I'm going to look at least as one commissioner through the clearinghouse rules is how does it compare to international standards? We'd want to ensure that around the globe they can use clearinghouses that we register and regulate here, and that these clearinghouses will meet equivalency And also, since we have a mandate, for the first time we'll have a mandate that swaps must go into clearinghouses, we would ensure that these are robustly managed for risk.
Mr. Chairman, I think it would be fair to say that the staff will propose standards that would, at a minimum, meet international standards, but in most cases exceed international standards because of the specificity which we will propose.
So it would be more specific, but not necessarily higher capital, it just would be more specific?
Correct.
Right,
But it will meet because the draft is a moving target, so we look at the draft as of a particular day,
Right.
and that's the language that we put in the proposal. When it comes to finalizing the rules, we will look at the draft again, because the new iteration of these standards will not be finalized by July of next year, because it is still in a draft form and it has to go to a consultation period. But because we are working on a different time frame, we will look at the language in the draft as of the day that staff proposes the final rules. So.
Thank you. Commissioner Dunn.
Just to follow up on that line, I guess I would also be concerned about we're not setting up an environment for regulatory arbitrage, that our capital requirements aren't so high that folks are saying, well, we're just going to go offshore or someplace else.
I think that's a fair comment, Commissioner, but at the same time, staff is very mindful of the fact that with Dodd-Frank, there is the potential for our DCOs to have large concentrations of risk. And if that happens, and we're always preparing for what could happen, and I always assume the best case scenario, which is a lot of business comes to our DCOs. And so we want to make sure that our DCOs have very safe and sound capital standards, because if you look at the notional value of swaps, it's 10 times futures contracts. So if you take even a significant percentage of that, the amount of clearing that will be done by our DCOs is going to be dwarfed by what they do. It'll be tremendously higher than what they do right now. So we want to be prepared for that.
Mr. Chairman, I'm intrigued about how the designation of the CITIC comes about, especially as we have to interact with the FSOC. And if you're going to have your first meeting today, so I guess we'll know more by Saturday. There are requirements in here that we have, and Phyllis, one of the things that I find intriguing in here is that we're requesting a living will, that we know how to unwind things, and that is to be done on an annual basis. And I know a lot of times that things happen very quickly, and from quarter to quarter may change very, very rapidly. Is the staff going to be updating there, and is there provisions for us to get updates on these living wills of how they go about? And then again, how does that dovetail with what the FSOC might be doing?
Phyllis, you want to take the first part, and I'll try to answer Commissioner Dunn's question about this afternoon's meeting, as best I know about this afternoon's meeting.
Well, there is always the option that the Commission can request information and receive it even in between the scheduled quarterly reports. One of the things we are also contemplating, and this goes to a future rulemaking, is establishing certain special events reporting requirements so that there are periodic reports that a derivatives clearing organization would have to provide, like financial reports. And then there would be certain circumstances that are a change, a significant change in the level of financial resources or, certain other aspects that affect risk management that would trigger a reporting requirement so that we don't find ourselves finding out after the fact or only on a quarterly basis that 3 days after the last report something dramatic happened. So we are in the process, and we're working with our risk surveillance people to come up with the special events reports, and I think that they will address some of those concerns.
All of that is going to take human resources to analyze. And again, Ananda, I would go back to my opening statement that I would like to see what these are going to cost and how we go about meeting those based upon the resources that are going to be allocated to us by Congress.
Commissioner Dunn and my fellow commissioners, the Financial Stability Oversight Council, which is under statute chaired by Secretary of Treasury Tim Geithner, will first meet this afternoon. And as I understand it, there'll be some closed session and open session, so the public will be able to see, and there'll be a transparency policy and the like. In terms of the financially, the systemically important clearing organizations, that council gets to make that determination, I think, by a two-thirds vote, if somebody reminds me, by a two-thirds vote. There's various criteria in statute in Section 804. Do I have? All right. Been briefed.
I'm giving you an A+ on your...
No. In the statute. So the council, though, today is considering, and I would hope, but is considering putting out an advance notice of proposed rulemaking about another section of this title, under Title I, about designating systemically important non-bank financial companies. I think that's under like Section 113, if I remember. But this topic as well will be discussed a bit. I plan to at least raise the intersection of what we've done this morning, and to raise with my fellow council members at the first meeting just that our timing, that it would be helpful, in my opinion, that if whatever designations are made would come in place, by next summer or so. Now, it might not align perfectly, but that's one thing that I would be hopeful of. So the council may, in fact, put out, we're not going to do it today, but they may, in fact, put out and ask the public comment on the systemic designation of what's called financial market utilities. We may have a short handful. We have 14 clearinghouses we regulate now. I know staff has estimated that would grow to maybe 20 or so. There may be a handful that are systemically relevant by the council, and that will be the council's determination. But also the SEC may have some they oversee. There may be payment systems that the Federal Reserve oversees. So all of them have to have some consistency, and I know the council will take it up. My hope, though, is that these designations might come in place by next summer, so that as our new rules come in place, of course it doesn't have to happen that way, but that's my hope. Is that... Commissioner Summers.
Just to follow up on that line of questioning, I would be interested to know about our coordination with both the SEC and the Fed on these rules, and if we anticipate that they will also be putting out rules for financial resources for their clearing organizations and any significantly important clearing organizations they may have.
Yeah, we've been consulting quite a bit with them. We've had meetings. We've shared drafts with them. We've, in some cases, modified our documents based on their comments. So both the Fed and the SEC in particular, and some of the other members of the Council as well.
Thanks. I have a more specific question for Phyllis, I think. With regard to the computation of the financial resources, I understand and think it's very reasonable to have the stress tests done on a monthly basis, because it's an evolving process, knowing where the risks are in the clearinghouse. The part that I'm not sure I understand is about the operating costs, and if that is more of a static number, and if we define what operating costs are, do we assume that all clearinghouses will calculate operating costs in the same way, and how do we figure out if what they're allocating for operating costs is appropriate?
Well, first of all, the monthly calculation is consistent with IOSCO, and the idea here is that the operating costs are based on their business plan, their budget, what they expect their expenses to be. We would not expect that number to change dramatically. Perhaps if they enter a new line of business or set up a new subsidiary, something like that. The calculation goes not only to what they think they're going to need, but what they have to satisfy that requirement. So that's what we're looking for. Even if the operating costs are static over the course of a year, what is the level of financial resources that you have? What financial resources do you have, and what's their value in order to satisfy that?
And the kind of calculations for operating costs, we currently do that, so that's something that's not really going to change for us, or this is different than what we currently apply?
We've actually been asking new DCO registrars to do that, and we started doing it as a result of the Commission's experience with one exchange/DCO, which engaged in what I would call just-in-time financing. And so it required a lot, meaning they would realize that they were going to go out of business if they didn't get money, and there would be a mad scramble to get money. And the Commission staff basically had to sort of shepherd them through this process. And at that time we realized that it would be useful for DCOs to be able to demonstrate that they had enough resources basically to pay the light bill and to keep on operating. And the other concern is we want to make sure that if they stop operating, they've got enough resources to be able to either liquidate all contracts or transfer all contracts, because the last thing we want to see is a disruption in a particular market because a DCO doesn't have resource just to be able to function.
If I can just add to that, the statute itself now requires this 1 year of financial resources to cover operating expenses. But even prior to that, as Ananda says, we have informally been applying that standard. An example of that is recently the Cantor Clearinghouse, Derivatives Clearing Organization registration. As among the conditions in the order that was issued, I think, in June, was this 1 year financial resources, standard. So it is, many of these standards are not really new. It's just we're codifying them in a regulation now. But they've been around and they can be satisfied and are being satisfied now.
Phyllis, that last part's very helpful to me, that you're saying much of what we're doing here is codifying what is either industry practice or what we put in orders and guidance, but given this new environment where we're mandating swaps into clearing and we have a whole systemic risk council, the FSOC, that we're trying to put these in a rule, get public comment on it, but put it in a rule. Commissioner Chilton.
I wanted to follow up on Commissioner Summers' question, at least get a clarification. So is the static part of this, does it stay the same always? Is it revisited when certain actions take place or on a certain time period?
Well, I think on a monthly basis, there is stress testing of the resources, and we require quarterly reports in the ordinary course to describe, to update us on the operating expenses and what the status of the financial resources is.
So quarterly.
So there are quarterly reports.
Okay, all right. One of the things that, I'd asked the last folks about comment letters, and I just looked when I stepped out here. Didn't seem like there are any comment letters on this one specifically. But I am curious if you can give me a little bit of insight into your thinking about the formula, where you say, well, we're going to cover the largest two entities or some other formula. Where did you come up with the two? Why wasn't it three? Why wasn't it one? Why wasn't it six? How did you come up with this?
I think we started because two has been discussed in the various international forums as a potential standard. They haven't landed there. But that's where it came from. We also, again, did some testing ourselves to see how that would work for our DCOs, and I think some of them do that themselves already as well.
Okay. Thanks, John.
Commissioner O'Malley.
I really have kind of a question for the Commission. We have talked about having a public meeting on segregation and bankruptcy. Bob Wasserman is leading that group. But it's all related to the clearing, and obviously under the larger clearing requirements and kind of the cumulative clearing needs we're going to have going forward under this act. I know we're planning a hearing on segregation. Would it be possible to have both Phyllis and John participate in that, or due to the fact that it's out for comment, that might prohibit having their participation?
I'm just trying to clarify. A hearing, or are you talking about the staff roundtable?
Staff roundtables.
I would.
That would be perfectly fine, because we're going to have a staff roundtable, in my view, which is open to the public. So, and it'll be recorded, there'll be a court reporter.
Okay.
And we'll just say that, we'll be talking about this matter, but whatever people say will form part of the comment file.
Yeah. Well, I know Nancy's already off the hook. She started this off with a comment period. But I think cumulatively we need to look at all the rules affecting clearing and the costs associated with that and the new requirements we're considering in order to get a better sense of the totality of this rule.
But I think that when the staff roundtables, because I think we'll have more than the segregation. I'm hopeful we're still going to have. I know I'm making news here. I'm not, but I'm hopeful that we'll have one on credit default swaps, because I think that we really need to hear the public, or our staff needs to hear from the public, with regard to the risk management standards for credit default swaps in clearinghouses and the risk management standards for credit default swaps at swap dealers. And as we're going to be doing business conduct standards to make sure to lower risk at swap dealers, and we're doing clearing rules at clearinghouses, I think that, as I understand it, staff would like to hear from the public in a roundtable on credit default swaps, and so it's the same question.
Essentially, yeah. I know we hadn't agreed on this, but I did want to make sure that both John and Phyllis are able to participate in that, and there wouldn't be any limitation due to the fact that it was open for comment. But
can I see our general counsel, Dan Berkovitz, is. So just the public can't hear you, but so Dan Berkovitz, our general counsel, says there'd be no limitation.
There'd be no limitations.
Perfect. Thank you.
So, Mr. Chairman and Commissioner, the current plan is to have a roundtable on the segregation and bankruptcy issues, credit default issues, and we can add these issues as well. Whatever subjects the Commission would like us to discuss, we'd be happy to do so. In fact, the current thinking is to have a one-day roundtable so that all of these matters can be discussed in one day.
Working with the Securities and Exchange Commission and coordinating.
Yeah.
Good. Mary said it would be good if you guys schedule it, though, because we're all so busy.
As long as we can have it here, we'll be happy to schedule it.
I think they'd even agree to that, as long as you handle the scheduling.
We can make a motion.
Yeah. Well, no, that's the other commission. Other questions?
Snooze, you lose.
Yeah. I just wanted to go back because I got the statute book here. There is, on these designation, Commissioner Dunn, under 804 also, and this is very important, a consultation and notice and opportunity for hearing. So the Financial Stability Oversight Council, as I recall it in 804, also has, before making any determinations, under this, it gives a notice and an opportunity for hearing for those individual companies that may be designated. And that's similar in a different context of what would be done for non-bank financial companies, but for these clearinghouses. So there would be, it's a long process, and it may take more than till next summer, but I'm just hopeful that maybe we could do it.
At that point, Mr. Chairman, we will already have made preliminary decisions.
Well, we will have made, if we're moving ahead with the proposals, we might not have finalized, but we will have proposed the financial resources, the participant, the risk management standards, and I think it's staff's. You're going to do this on each one of these. Here's the base, and here's a little bit extra if needed.
In some instances, that we're going to say that the standard DCO standards would apply to all, but in some of the areas we would have these enhanced proposed.
Any other questions for? So I think I've entertained a motion. I just want to say that I am supporting this notice of final rulemaking. I think it's really an important first step. Ananda called it two rules. We're packaging it, I guess, in one document, so it'll be one vote.
That's
Is
right.
that right? But we're going to have 4 or 5 of these along the way. We'll probably see Phyllis and John and Ananda in these seats several times in November and December. We're coordinating closely with the Federal Reserve and the SEC and the other regulators as well, but particularly those, and the Council, to the extent the Financial Stability Oversight Council starts to, be very helpful. I'm supporting of them mostly because they're staff recommendations and they're consistent with the newest draft CPSS IOSCO. As I understand them, they're largely consistent with the orders and guidance that we put out. We're not trying to exceed international standards, but these proposed rules have my support because I think they're in line with, they may be more specific, but they're in line with those international standards. And that's the key basis of where I am on this. Of course, the Council will designate the systemically important clearing organizations. We won't, but I think it is also, I'm supportive that we sort of anticipate that. And I think it's important as a Commission to show that where we might come out on that, so when the Council is doing those determinations, they can take that into consideration and see at least our proposals, and that the parties that might be designated, when they have that opportunity for a hearing and public comment, those parties will have some, sense of where we might come out on this. So some have asked why we're doing the systemic important pieces now, and the reason I'm supportive is I think it gives market participants, clearinghouses, a sense of where we might come out, and I think it's better informing the public and the Council. So
certainly they would take our lead, Mr. Chairman. I'm just struck that we are faced with a number of chicken and egg situations here as we try to go through this. And again, it's been tough on the staff to try to clairvoyantly to figure out where we're going to be and what's going to be in the forward. And that's why they've worked so hard, and it is important that we get public input into this as we go forward. And the realization right now, these are all proposed until these things get together.
That's right, but with 288 days, we want to get the proposal out, get the comments, and that's. So I'll call the vote. All in favor?
Aye.
Aye.
Aye. Any opposed? The vote being unanimous will, again, I think, be submitting it to the Federal Register shortly. Then it get a chance, Nancy gets to chat about governance with regard to designated contract organizations, DCOs, designated clearing organizations, designated contract markets, and swap execution facilities. Nancy.
Thank you, Chairman. Commissioners. Today, staff is recommending that the Commission approve a notice of proposed rulemaking to implement, among other things, Section 726 of the Dodd-Frank Act. Before discussing substance of the proposal, staff wants to echo the Commission's emphasis on the importance of public comment. We've asked many specific questions in the proposals, and we hope to receive specific answers and thoughtful answers from the public, which will inform our final rule. Section 726 of the Dodd-Frank Act requires the Commission to promulgate rules to address potential conflicts of interest in connection with the interaction between swap dealers and major swap participants on the one hand, and certain DCOs, DCMs, and CEFs on the other hand. And it specifically empowers the Commission to adopt numerical limits on control or voting rights that enumerated entities may hold in certain DCOs, DCMs, or CEFs. The enumerated entities include certain bank holding companies and non-bank financial companies, as well as swap dealers and major swap participants. On August 20th, 2010, staff of the Commission and the SEC held a joint roundtable to discuss potential conflicts of interest in DCO, DCM, or CEF operation and possible methods of mitigating such conflicts. Based on roundtable discussions, as well as external meetings and materials that the Commission has posted on its website, staff has identified a number of potential conflicts of interest. With respect to a DCO, conflicts of interest may present themselves in, among other things, determinations regarding whether a swap contract is capable of being cleared, the minimum criteria that an entity must meet in order to become a swap clearing member, and whether a particular entity satisfies such criteria. With respect to a DCM or CEF, conflicts of interest may present themselves in, among other things, determinations regarding the balance between advancement of commercial interests and fulfillment of self-regulatory responsibilities, including in regard to DCM or CEF access. In order to mitigate such potential conflicts of interest, staff proposes certain structural governance requirements as well as certain limits on ownership or exercise of voting power. Staff notes that more substantive requirements on the determination subject to conflicts may be covered in other rulemakings that will be coming in the fall. The proposed structural governance requirements build upon the acceptable practices that the Commission previously adopted for the DCM conflicts of interest core principle. In general, the proposals aim to mitigate conflicts of interest at a DCO, DCM, or CEF through introducing a perspective that is independent of competitive, commercial, or industry considerations to the deliberations of governing bodies for those registered entities. More specifically, the Notice of Proposed Rulemaking requires that a DCO, DCM, or CEF Board of Directors be composed of a certain percentage of public directors. It also requires that each DCO, DCM, or CEF have a nominating committee and one or more disciplinary panels. It further requires that each DCO have a risk management committee and each DCM or CEF have a regulatory oversight committee as well as a membership or participation committee. The Notice of Proposed Rulemaking specifies the percentage of public directors that must be included on each committee, and with respect to the DCO Risk Management Committee, the percentage of customer representatives. The Notice of Proposed Rulemaking also includes modifications to the definition of public director to conform with the definition of independent director that the Securities and Exchange Commission had proposed in 2004 and currently accepted practices among the listing companies. Given that the Commission is currently regulating and may in the future regulate certain of the same entities as the SEC, staff believes that greater harmonization is important. Turning now to limits on ownership and voting power, staff believes that such limits enhance the structural governance requirements in that such limits restrict the direct influence that certain shareholders may exert through election or compensation over the DCO, DCM, or CEF Board of Directors. Staff believes that such influence could, among other things, affect the independent perspective that we demand of public directors. Because staff is primarily concerned with direct influence, the Notice of Proposed Rulemaking does not impose limits on non-voting economic equity. With respect to a DCM or CEF, the Notice of Proposed Rulemaking states that no member or its related persons may beneficially own more than 20% of any class of DCM or CEF voting equity. An identical limit applies to the exercise of voting rights. With respect to a DCO, the notice proposes two alternatives as well as a waiver procedure. Under the first alternative, no individual DCO member and its related persons may beneficially own more than 20% of any class of DCO voting equity. Additionally, the enumerated entities and their related persons, whether or not they are DCO members, may not own more than an aggregate of 40% of any such class. Identical limits on the exercise of voting rights apply. Under the second alternative, no individual DCO member or enumerated entity, whether or not it is a DCO member, as well as related persons, may own more than 5% of any class of DCO voting equity. An identical limit applies to the exercise of voting rights. In the case of a DCO, staff recognizes that circumstances may exist where neither the first nor second alternatives would be appropriate. To enhance flexibility, staff is proposing a procedure for the DCO to apply for and the Commission to grant a waiver of the limits specified in the first and second alternatives for a reasonable period of time. Staff believes that proposing different limits on ownership and voting power for DCOs on the one hand and DCMs and CEFs on the other hand makes sense given that the two different types of entities have differing competitive dynamics and degrees of systemic importance. Currently, staff does not propose to distinguish for purpose of the notice of proposed rulemaking between DCOs and DCMs that operate only within the commodity futures and options sphere and those that operate within the swap sphere. In certain ways, the two types of products are sufficiently similar that the staff does not believe that the Commission should create an incentive for regulatory arbitrage due to differing governance requirements. Finally, staff would like to observe that the notice of proposed rulemaking provides for a long transition period, 2 years, or 2 regularly scheduled board elections, whichever is earlier. So, again, we would like to emphasize that we welcome public comments and we will devote attention to reviewing public comments in detail and that the final rule will depend on such comments.
Thank you very much, Nancy. I will now entertain a motion on the recommendation of staff on the proposed rule regarding governance issues for the clearinghouses and exchange platforms.
So move.
Do I hear a second? Second. The motion having been moved and seconded, we'll now ask questions. Nancy, I know that you've engaged in a lot of discussions with the SEC and in no way projecting where they will be because that's a separate agency and commission, but can you give us a sense on whether you know of, as of today, of any material differences in this and what your discussions with the SEC staff? I mean, is there any recommendation they've made to us that you haven't done your best to incorporate?
I've done my best to incorporate every recommendation. I think that the SEC staff in certain instances may have a slightly different view with respect to some of the percentages that we've proposed for structural governance requirements, and that view may be, I think,
well,
more
you don't
stringent.
need to say where they are, but
Right.
But I mean, we are, this is, I think. We have a body of regulations that have grown up over 70-plus years in the futures world, and they have a body of regulation that's grown up over an equally long time in the securities world. And the President asked last summer that we try to seek to harmonize. The swaps area is a new area that's sort of in between securities and futures, and so in some instances it will be possible to make sure the swaps regulation is uniform, but taking the best, and hopefully just the best, out of the securities world and taking the best out of the futures world. I think this area, this governance area, particularly for swap execution facilities, because there could be CEFs that do both securities-based swaps and swaps. I'm hopeful that at the end of this, next summer, we end up in the same place on this governance issue. And I think we're there, at least on the proposal stage, but I, for one, am going to be very mindful to try to be in the same place when we end up on this at the end. My second question is just on these there's no aggregate limit on swap execution facilities being proposed. Is that right?
That's correct.
But there is an aggregate voting limit on the clearing, which only exists if one individual member has more than 5% voting control. Is that right?
That's correct. I mean, there are two alternatives. If any one individual member has more than 5%, then there will be an automatic default to the second alternative, which is 20% per
But is it
individual
correct?
member in
It's correct
aggregate.
if no one's over 5%.
That is correct.
Thus, then there's no aggregate limit.
Yes.
So in essence, the aggregate only kicks in if somebody's kind of larger.
Over. Yes, right.
And then, and I think it was a terrific suggestion that Commissioner Amalia made, and I mean, this is a very deliberative process, and the public should know about having to retain some flexibility, that we have a waiver ability in there. That's included as well.
That's correct.
Okay, I don't have any. One other thing, on the non-ownership side, on the governance rules, the board governance rules, I take it that they're quite similar, maybe not identical, quite similar to what we've recently adopted for contract markets, and in this case we're sort of extending them to clearing organizations and SEFs and asking a lot of further questions. Is that?
That's right. We've tried to defer to previous commission precedent.
Okay, thank you. Commissioner Dunn.
Thank you, Mr. Chairman. I know in 2007 the Commission had adopted SRO governance, and many of them are this last month been put into place, and it will take some time to actually fulfill all of these proposals that we've got in the regulation. I am concerned about the requirements that we have in there for public membership, especially in the regulatory oversight committees. I believe it's for the SEFs, it's 100%. Is that correct? And I want to be reassured that we have people that are in the business that know what the impact of these committees are going to have on the overall operation. And if we're excluding industry folks or folks that are non-insiders, I guess, will, as they fill these various boards, will there be a large enough pool out there to ensure that we get people with the expertise needed to make recommendations from the board positions?
Right. I mean, that's a very important question, and I think that there are people who are out there. I mean, for instance, ex-employees or academics.
This isn't a full employment act for ex-employees.
I know. I understand that, but there are people who are not currently affiliated with industry, and also, I mean, for the Regulatory Oversight Committee, for DCMs, we've in 2007 required that DCMs have to 100% independent. So, I mean, DCMs have now currently come into compliance. We gave them a long transition period as we're contemplating for this proposed rulemaking. And there should be no reason that SEFs cannot also come into compliance with a 100% regulatory oversight committee that's public.
The second question I have is on ownership. And with the requirements that we have in there, are we assured that this will still allow for the new startups that will be significantly financed, and will it not stifle competition?
I think that the various alternatives that we've proposed will actually leave room for new startups. I mean, for DCMs and SEFs, basically we're saying a 20% single member limit. And I mean, that would mean that a new startup would need 5 member investors, and it seems as if 5 is not necessarily an excessively onerous number for a new startup. Plus, they can have outside investors as well that are not members, and the same limits apply for SEFs. I mean, for DCOs, we have various alternatives, including a waiver procedure. And so with respect to the 5% limitation, if a DCO wants to organize itself as more of a utility, it will have a chance to, and it will have 20 members. And if it would like to organize itself with more concentrated membership, we have a structure that would provide for that. And we ultimately have the waiver, so if staff believes that having a new DCO in the swap space is important, then staff will recommend that the Commission adopt the waiver.
To the public, I think this is an extremely important part, and as a commissioner, I really do look for public comments in this area to help guide my decisions.
Before I turn to Commissioner Summers, I want to associate myself with this last point. I mean, this had a lot of debate in Congress. but I think it really is something that we need the public input and a broad range of views on this. Commissioner Summers.
Thank you, Mr. Chairman. I don't have any questions, but I do want to comment specifically on this proposal regarding governance and conflicts of interest, and specifically where I think the Act and congressional intent leads us. Section 725D of the Act directs the Commission to adopt rules mitigating conflicts of interest, and then Section 726 of the Act provides that the Commission shall adopt rules which may include numerical limits on the degree of control or voting rights that certain enumerated entities may possess with respect to DCOs, DCMs, and CEFs, if the Commission determines after a review that such rules are necessary or appropriate. I recognize that these provisions direct the Commission to adopt strong governance rules and to mitigate conflicts of interest in connection with the interaction between swap dealers and major swap participants on DCOs, DCMs, and CEFs in which they may have a material debt or equity investment. In my opinion, however, the voting equity restrictions being proposed are not necessary or appropriate to mitigate the perceived conflicts, and in fact may do more harm than good to the emerging marketplace for trading and clearing swaps. In 2009, after more than 2 years of study, the Commission finalized acceptable practices to provide a safe harbor for complying with Core Principle 15 for DCMs dealing with conflicts of interest. I support making those acceptable practices mandatory for DCMs, DCOs, and CEFs, as augmented by some of the additional provisions being proposed today, such as the Risk Management Committee for DCOs. I believe that strong governance rules coupled with the Commission's ultimate authority to determine which swaps must be cleared under Section 723 of Dodd-Frank is sufficient to ensure that swaps that should be listed for trading and cleared will be listed for trading and cleared. I have grave concerns that the proposed limitations on voting equity, especially those proposed for enumerated entities in aggregate with respect to DCOs, may stifle competition by preventing new DCMs, DCOs, and CEFs that trade or clear swaps from being formed. The Commission recognizes in the preamble to the proposal that the enumerated entities will be the most likely source of funding for DCMs and CEFs, and thus chose not to propose the aggregate limits for trading facilities. I believe the same logic applies with even greater force for DCOs. I'm equally concerned that a number of recent entrants into the swaps trading and clearing space will potentially be required to disband their operations if they're unable to attract the required amount of non-voting equity within the 2-year, 2-board election cycle proposed. I also want to note that the European Commission explicitly rejected ownership limitations in its proposal for regulating OTC derivatives, which they announced on September 15th, because such limitations may have a negative consequence for market structures, and I agree with that. I hope that we will be mindful of this global consistency as we move forward. The marketplace for trading and clearing swaps is in its infancy, and I strongly believe that the limitations the Commission is proposing will have the effect of inhibiting emerging competition rather than promoting it. I therefore am not going to be supporting the proposal. Thanks.
Commissioner Summers, I thank you for all your input and many of the points you raised. I will be supporting it, but these are the exact questions I'd like to hear from the public on. So part of the reason I am supporting this, including the aggregate limit in certain circumstances, because it's not an aggregate limit in all circumstances, is to really hear from the public on this important issue on clearing houses. But I think we share a view that these are challenging issues. Where I come out is I'd like to continue the hearing from the public, and I really do reserve my. Commissioner Dunn's so good at this all the time, saying he's reserving till the final. I'm very much on whether there's an aggregate position limit. So Commissioner Chilton.
Yeah, actually, I agree with Commissioner Summers, too, on a lot of these things. I'm going to support it also, but I think those are really good questions. I mean, Congress wanted to make sure that DCOs didn't act solely in their self-interest, despite what might be a public interest. But that doesn't mean that government should be a control freak. And I'm not suggesting this proposal is, but we have to ensure that we're, balanced here and that we hit the right level. I've met with a lot of folks, and I've mentioned the comments that we've received on the other tool, or didn't receive them on the second one, but received them on the first one. And I know we have a bunch on this, and we've had the governance roundtable. It seems to me that some of these questions that Commissioner Summers is asking, some of the questions that were being raised with me in the meetings, are really about more texture to the rules. And for example, if you go to the Act, to what Commissioner Summers was talking about, 726C, it says that in looking at conflicts of interest, we shall consider equity and ability to vote. But there's also an important addition to that list. It says that we shall consider governance arrangements at the same time. So, for example, I've met with folks who say, well, we have a lot of ownership, but we don't actually have a governance vote. And so, setting just a hard cap limit may not be appropriate for them. So as we go forward and get these comments, I hope we'll put a little bit more texture to these and listen to what makes sense. And again, that we're not control freaks on this, but we're hitting the right balance. So I don't really have any questions unless somebody wanted to respond to that.
I have no incentive for being a control freak, so I would welcome the public to comment, and that will definitely help inform staff opinions.
Yeah, and my comments weren't certainly personally directed at anybody. It's more a general government thing. And there's a lot of folks in government who are control freaks. Thank you.
If I could just make a general observation, Commissioner, I realize that this is a difficult task because on the one hand, clearinghouses are not the same as exchanges because if the clearinghouse fails, trading fails. And so the argument from one side is, if I'm a clearing member, my money is on the hook, so therefore I should have a say in risk management. I should have a say in what clears. And that's a reasonable argument, and it's hard to deny the force of the logic behind the argument. It worked well in an environment where all futures contracts have to be clear. There is no exception. There's no end-user exception. There's no exception whatsoever. You list a futures contract, the law says you must clear it. Now you've got an environment where it's sort of backwards. The first decision is something going to be cleared? And then if something is going to be cleared, then something does it have to be traded? And here, the same concerns, well, you've got new concerns. The new concerns are, well, if you have a group of people who've benefited from the opacity of the OTC markets deciding what is to be cleared, then the incentive for them is, let's not clear it. Number one. Number two, the second consideration is that a lot of players who want their products to be cleared are not getting access. And then that is some of the comments that we have heard, that they're not getting access to the clearinghouse because they're not part of a particular group. And I think we need to be mindful of that as well. So I guess what I'm saying is there needs to be a balance. And this is the staff's view on a preliminary basis as to how to achieve this balance. But certainly the comments would inform staff and hopefully inform the Commission.
It's these, thank you for that, Ananda, but it's these idiosyncratic things I want to make sure we look at. Look, I'm in favor of board independence. I think having diversity on boards is a big plus. I think it helps markets. I think it helps consumers in general. So I like diversity. I don't want anybody to think that's not the case. But we just need to make sure that we're taking in all these comments, particularly the ones that are idiosyncratic to entities that may have a real point about how this could adversely impact them. We want there to be lots of competition. I want there to be lots of competition there. And to do that, we need to make sure that we have both a rule that's flexible but also does what Congress intended. Thanks.
Thank you, Commissioner Chilton. Commissioner O'Malley.
Thank you, Mr. Chairman. Thank you for your cooperation, the staff's cooperation, including waiver authority to give us some flexibility or at least have that considered in this rulemaking. I think, Ananda, your point is spot on. People have asked about access to clearing, and I think that's a very important issue. I think that is also addressed in the open access provisions in 723, and then the participant and product eligibility provisions in Section 725. I think this rulemaking, especially on the ownership rules, attempts to solve a problem that these other sections may be able to address more effectively. And I don't believe that this rulemaking specifically takes that into account. So I have a concurring statement here that I'd like included with the rule, and in that I raise these questions, and I hope that we'll be able to solicit some good public comment on the balance between ownership and access. We've heard those anecdotally. We've heard the stories about access to clearing. We want to make sure we can get good open access to clearing, get products cleared, and the breadth and the depth in the market. That's important, and I hope those tools are more effective. I don't think the ownership rules are going to be as effective in reaching that same objective. So I hope we get some good comments on this. I'd like to associate myself with the comments of Commissioner Summers as well.
Commissioner Amalia, I agree with you. I think that open access in a number of ways, that participants can be members. You know, in the futures world, we have 127 futures commission merchants right now, and pretty much the futures clearinghouses have figured out a way to have generally open access to those 127 members. The swaps clearinghouses, some of whom we already regulate, have a much more exclusive club. And I think that I'm looking forward to the staff's recommendations on participant membership in particular, that we can make sure they're more inclusive, balancing risk management, but I, for one, think they've been too exclusive, sometime even, frankly, possibly hiding behind risk management to keep startup swap dealers and smaller swap dealers out of the club. So I think you're right that there's participant membership and that there's non-discriminatory open access to trading venues, that the swap execution facilities can all have access. And this will be different than the futures world. The futures world has grown up around the globe to be vertically integrated. And we're not suggesting a change to that. But in the swaps world, that there's some open access to these trading platforms. Those are key access things I concur with you. I think that we really need to see how the staff recommends rules for 725, 723, and, of course, the clearing eligibility determinations.
Mr. Chairman, listening to the commissioners and thinking about my earlier statement, I do think part and parcel of the Dodd-Frank Act was that Congress thought there was too much concentration, primarily in the swaps area. And we have to take that under consideration as well. What is the spirit of what Congress intended to do? And so that will also motivate me.
I would say for the public listening, this is how we would like to talk with each other. The Government in Sunshine Act says that no greater than two of us can get together at any one time and deliberate unless we're in front of the public. So you will see in these hearings that we will deliberate in front of you, because I'm not committed to having these sort of be stiff, just staff presentations and votes up and down. So I apologize if people are a little bored with us going back and forth, but it's the way that we get to deliberate. But are there other questions for the staff on this one, having the vote? I am supporting the rules here. I think, like all of my fellow commissioners, including Commissioner Summers, we really do look forward to public comments on this. I'm supporting them not just to get the public comments. I do think that there's something positive about having a diverse group of input into governance. That governance is open to diverse views and consistent with what we've done on designated contract markets. We're trying to bring those board governance rules to clearinghouses. On the voting control, I think we've had enough back and forth, but I'm supporting it. I think we're putting an aggregate in certain circumstances on clearinghouses to get the public view as to whether that's appropriate. but it has a waiver and it has a way to have more diversity. So that's where I come out on it. But with that, I was going to ask all those in favor to say aye.
Aye.
Aye, and opposed?
Aye.
The vote being 4-1, we will be sending that as well to the Federal Register. I understand that I just want to make sure that I ask also unanimous consent to allow staff to make technical corrections to the documents voted on today prior to sending them to the Federal Register. You'll see any markups. So, I mean, but whatever technical corrections, apparently there might be a couple typos and different things here and there. I don't know.
So moved.
Second.
All those in favor?
Aye.
There are other things I need to do. I'm just going to make sure I do all the right stuff. So if there's not any other commission business, I just want to thank my fellow commissioners again. I think this is a very healthy and constructive process. We're going to be doing a lot of this together. I think our next meeting will be October 19th. Again, we'll be trying to do these approximately weekly. We'll let the public know the specifics of those, the topics to be discussed. And I think the last motion of the day is to, do I hear a motion to adjourn the meeting?
So moved.
All those in favor? Aye. Any opposed? It seems it's unanimous to adjourn this meeting. Thank you.